Welcome to the I Got Fired podcast, a podcast where we talk about issues important to people who have been fired or afraid that they might be. I am Tom Spiegel, founder of the Spiegel Law Firm and host of the podcast. Just a brief note, unfortunately, my camera has decided not to work today, so for these next two, you won't be able to see my pretty face. You will only have audio, but of course, if you're listening to this on just a podcast feed, then that shouldn't matter to you. So today we're going to continue our series on mediation. Our last episode, we talked about mediation generally and also mediation before the EEOC or other administrative bodies. And today we're going to talk about mediation before a judge. And the usual disclaimer, this podcast is intended for educational purposes. It's not intended for specific legal advice. If you need advice specific to you, then you got it. You need to hire a lawyer. So with that said, let's talk about mediation before a judge. So mediation, as we discussed in the last episode, the broad mechanics of it generally are the same. You've got your mediator who's going to have the opening statement about confidentiality, and then they'll give parties a chance to make their own opening statement if they wish, and then they split the parties into two different rooms, and then the mediator essentially does shuttle diplomacy back and forth until the case is settled or until it looks like settlement's not going to happen, and then they'll end the mediation. One difference between the EEOC mediation or mediation before an administrative body and before a judge, and let me say, who the judge is may depend. Depends on what court you're in. If you're in federal court, the mediation is usually going to be with what's called the magistrate judge. And in the federal system, usually you have two sets of judges. You have what we call the Title III judges, the ones who are nominated by the president and appointed by Congress and all of that. And they have the lifetime appointment. Those are your kind of the main judge. And then you have a magistrate judge. And the magistrate judge is usually someone who essentially they are hired into the position by the court. They're a judge and can make decisions, and they will generally make decisions about preliminary matters. And by that, I mean, scheduling. If there are discovery disputes, those will often be heard by a magistrate judge. And they often are the ones who will conduct the mediation. And some of them are very good and very bright. And just like in any profession, some of them are not. But you can have longtime magistrate judges who are very experienced and very good and who work closely with their assigned judge. So it's often the magistrate judge. If you are in a different court, it varies. If you, for instance, are in DC Superior Court, you will probably have the judge who will hear the case who will actually be the mediator. Some courts have their own separate mediation program where you will go and have a private mediator handle your case or handle the mediation. In those instances, it's often very similar to being before an administrative body in terms of how prepared the mediator is going to be and how effective the mediation is. But let's assume for this purposes that you're going to be before a judge in some capacity. So one of the big differences is that often this will occur, if you're before a judge, there's been a complaint filed and you will have probably proceeded some distance into the litigation. By that, I mean, you've at least got the complaint filed. There's been an answer filed. Sometimes you'll have mediation occur at that stage. Sometimes it won't occur until after summary judgment arguments have been heard, and that can be a ways into the case. That's particularly true in a lot of federal courts. And so that means that paper discovery has happened. That means that your depositions have happened, and often summary judgment has been filed, and there's been an opposition filed by the employee. It's usually, in these cases, in employment cases, the employee is usually the one to file the opposition because a summary judgment motion is an effort by the defense to get your either the whole case kicked out of court or at least some claims kicked out of the case. But the upshot is by that point, there's what we call a substantial record, right? So you've got, this is all part of the court proceeding that can be used at trial. You've got your answers to the interrogatories. You've got the paper discovery. You've had a number of depositions and you've got summary judgment that has been briefed by both parties. And so there's a lot of paper at this point for the mediator to look at. But again, it can vary. It happens sometimes that you'll have early mediation, particularly if both parties are interested in that, which can happen right after the complaint is filed. So in that case, the judge will have less information at his or her disposal. But what you will often see, one difference is that unlike EEOC administration or administration before another administrative body, is you're going to have to send some things to the judge beforehand. This is particularly true in federal court. It's pretty lengthy. Both parties have to basically give a summary of their argument, and this is all confidential. This does not become what we call part of the record, that can be relied upon in court. But you send this information to the judge and you set forth your mediation position, what you think your strengths and your weaknesses of your case are. And again, just like any mediation, you want to leave a little bit of gas in the tank. You don't want to lay everything out at that point. 80% of it, but you want to leave some gas in the tank. For instance, maybe you say your low point is, I won't settle for less than $80,000. But the truth is, if push comes to shove, you'd settle for 70. But that's a matter of strategy for you to talk to your attorney about. But nevertheless, the judge is going to come into this with a lot of information. And this, again, is different from an EEOC administration where they're going to have the charge, but the mediators, they're not going to have that much information about the case. And even assuming, which is an assumption, that the mediator is really involved and very good, they'll walk into that room with a folder with a couple of pieces of paper in it. Whereas a mediation before a judge, again, depending on how far you are into the case, but the judge, you may walk in there with notebooks full of information. So the judge at this point, remember, they are very invested in getting your case resolved. Judges have, in most courts, have very busy dockets. And by that, I mean the number of cases that they have. They often have criminal cases in addition to civil cases, and they would prefer to get cases resolved. That doesn't mean they're going to be unfair or they're going to strong arm you. A lot of cases, fail at mediation even at this stage. But nevertheless, they really, for the most part, are going to put their shoulder behind the wheel and try to get this done. The magistrate judge wants to help the senior judge or the judge that they report to clear his or her calendar for as much as possible. And of course, if you're, before the judge that's actually going to hear your case, they don't want a trial with you. And in most instances, not that they are going to run from it. Judges, that's why we have them, is to have these trials. But nevertheless, they're busy. They've got a lot of things going on, and they would certainly be just fine if parties could reach a resolution and could avoid a trial. So for that reason, unlike the EEOC, or kind of what I'd say pre-litigation mediation, this person is likely going to be really prepared and really kind of, delve into the facts. And of course, this is a sitting judge, right? So unlike an EEOC mediator where they're not going to decide the case, parties, when I say parties, you, the employee, and your employer or your former employer, the attorneys for both sides, they're going to listen to this judge. This judge has got substantial heft. And so when the judge says something like, well, I've seen a lot of these cases, let's say they're talking to the defense, your former employer, I've seen a lot of these cases. These facts are pretty strong. I'm not saying that you can't beat it at trial, but, I had a case just last week with facts weaker than this and the employee won. So defense counsel, you might really want to consider, putting some more money on the table. And again, if you're having a mediation with the court's going to require that parties have settlement authority. And for the employee, for you, that's not a difficult thing because you're there with your attorney. But for the employer, often they'll have insurance coverage and they need to get the insurance adjuster there. And the thing you should know kind of how the sausage gets made from the employee's side to understand that these employers getting their insurance adjuster involved often can be very difficult unless your case is a really big one. These insurance adjusters, they've got a lot of claims they're trying to get resolved. They maybe have barely paid attention to yours, particularly if it's one that's, let's say it's low six-figure kind of case. Again, a lot of money for you and for me and for most people, but for an insurance adjuster, this is not. Of course, they're trying to make the insurance company money, so they don't want to just open the checkbook. But they're really paying attention to their bigger cases. So this may be the first time that the insurance adjuster has really paid attention to this case. And if they're in the room, sometimes they'll be on the phone, but if they're in the room, that's really powerful because again, you don't know what your former employer's attorney is telling you, right? They're obviously involved with the insurance adjuster, but you don't know what they've been telling them. I'm not saying they're being dishonest with the insurance adjuster, but they may not have had kind of a come to Jesus moment with the insurance adjuster where they're like, look, you need to settle this case because, we really might lose. So this may be the first time when everybody's in the room. I mean, by everybody, I mean the defense counsel, the insurance adjuster, maybe some of the other key witnesses in the case, for the judge to come in and say, look, you might want to think about putting some more money on the table. That's very powerful in a way that does not generally happen in an EEOC mediation. And of course, the same is true on the employee side. You may hear get some tough love from the judge yourself, where the judge might come in and say to you, like, look, I had a case like this last month, and I thought they had stronger facts than what I see here, and the employee lost and got zero. Again, that's good information for you to have as the employee. So that's the big difference, with a couple of big differences when you're having mediation before the court. It's often going to be with the judge. He or she's going to have a lot more information about your case. I was in a mediation a while back with a magistrate judge in the Eastern District of Virginia. And I mean, he treated it like a summary judgment motion. And by that, I mean, he was really into the facts. He was asking both parties questions about their case, about what witnesses had said. I mean, he was really up to speed on the case and was pushing both sides for details about, hey, what evidence do you have to support this? What does your witness say about this? I mean, he really put his shoulder behind the wheel and pushed both sides to basically say, look, we're going to treat this like a mini trial. And I say that a little bit loosely because it's not as if he's talking to witnesses. And again, this is not part of the record. This remains confidential. This is not going to be part of the case if it goes to trial. But he sort of treated it like, okay, let's, what facts have you got for me? If we're going to have a trial, each side, how are you going to prove your side? So you may see the judge do that, really get into the weeds in your case and push both sides, which is a good thing, right? You want that from the judge. I will say, judges are people too, and institutions, like every institutions, some of them are very good and very bright, and some of them are not. And some of them, even if they're very good and very bright, have bad days or are not as prepared. So it's entirely possible that you get before the judge and they've barely read the complaint, they've barely read the answer. They don't get in the weeds like the magistrate judge I was before. So, it really runs the gamut. But all things being equal, the judge is going to come in prepared, going to come in motivated to settle the case and willing to spend some time to get that done. And again, to have the authority, again, not to decide the case because they can't decide the case at mediation, but to, kind of very transparent with both sides about how the judge sees the case, right? And again, they haven't seen witness testimony usually by this point. They're looking at transcripts, they're looking at paper, so things can change, and judges understand that. When you get to trial and you get people on the stand, it's not uncommon at all for them to have submitted a very impressive affidavit, for them to have done well in the deposition, and then fall apart on the stand under cross-examination. And those sorts of things can turn a case around completely. So judges know that. It's not as if they have decided the case by looking at the record or the information that they have, but they're going to have a lot of information, and it often the case will come out like you expect, like you see it on paper. That's how it's going to come out at trial. So again, they're not going to decide the case. They understand that things can change, but it means a lot to both sides to have a judge say, hey, I've been on the bench for how many number of years. I've seen a bunch of these cases and I'm looking at this now and I'm saying that your case, again, maybe to the employees, isn't worth what you think it, or what you suggest it's worth here, or the opposite to the other side, which is an employee, is really helpful. Again, this can be the first time that maybe, everybody on the defense side gets some tough love from a judge and says, look, insurance adjuster, if you want to get this case done, the other side's got some really good facts here. You need to put some more money on the table. And that carries a lot of weight. So that's some of the main differences between, the mediation before court and mediation before EEOC or another administrative body. Can be very productive. In a lot of cases, it's required. Again, courts generally want to get these cases resolved if parties can reach some kind of agreement, and this mediation is required. One thing to think about when you are working with your attorney, and if you're in court, hopefully you have an attorney at this point, is when you do the mediation. That's not completely within your control. The court really decides that. But if both parties are motivated and you come to the court and you say, hey, we would like early mediation, most courts are going to help you with that and will conduct the mediation, say, before depositions and before a lot of paper discovery has been done, because that's going to add a lot of expense to both sides to get to kind of summary judgment level. So if both parties are willing to do that, then often you'll get a judge who will kind of move the mediation date up. Now, if one side or the other is like, there's no point in mediating at this time, then courts generally aren't going to do that. They're like, okay, well, let's develop the record. Let's have some discovery. Let's have some depositions. And then we'll have mediation, after summary judgment when we have a lot more facts in the case. So, but there is a little bit of strategy there, and you want to be thinking about that as you evaluate your own case and as you are working with your lawyer. So that is the end of mediation and mediation before courts. I hope you found it helpful. If you get to that point, remember, it's a good thing, and you want to come in as prepared as you can. And as we talked about before, you want to have thought beforehand what your number is, what your range is, but also, again, what some of those important non-monetaries might be to you. For example, like whether or not you're willing to sign a non-compete, whether or not you're willing to sign a non-disclosure, whether or not you're willing to sign a non-rehire provision. All these things you need to talk about with your attorney, because, again, judges may not go over that. Usually mediation at this point is still about, let's get to the dollar figure. So you want to make sure you've priced that in. If you're willing to settle for, let's say you're willing to settle for $80,000 if you don't have to sign a non-compete. But if you're going to have to sign a non-compete, you need, I'm just pulling a number out of a hat, let's say it's 120, right? The judge may not be thinking about those factors. And so you and your attorney need to think about that when you walk in, and be very clear with defense counsel, like, here's the number we're looking at, but assuming that these provisions either are or are not in the settlement agreement, because again, there's nothing worse than spending all day, getting to a number that everybody agrees on, only to realize once you see the fine print of the settlement agreement that there are things that you are willing to agree to, at least at the settle amount that you came up with. So again, as is always the case, go in there knowing, what non-monetary factors are really crucial to you, have them baked into that as part of that settlement agreement. Again, because it can be a chip that will help move things one way or another. Let's say parties are stuck at, $100,000, and that's lower than you're willing to accept. But if you can get defense counsel say, okay, we're going to not have a non-compete, and that's important to you, sometimes that's an easier give for defense counsel, because it doesn't involve putting money on the table for them to waive a non-compete or to waive some kind of provision in what the ultimate agreement will look like. But you want to be able to play that chip, kind of mix my metaphors here, when the iron is hot. You want to be able to use it then, because once everybody's gone, they've left the judge's chambers, everybody's, gone home, gotten a good night's sleep, and had their cup of coffee in the next morning, it can be hard to undo or to kind of go back and renegotiate some of these provisions. Not impossible, but it becomes a lot harder. So it's better if you walk in there prepared, knowing, what your number is, what your non-monetaries are, kind of what, you want to have kind of a vision of what that settlement agreement is going to look like before you sign anything. And again, with court order mediation, a lot of times what they will do is they will have parties sign something at the end of the mediation where it's not the final settlement agreement, but it's sort of an agreement in principle where both sides say, okay, we agree to this number and parties are going to work on settlement language, following this, but everybody is kind of on the same page. So again, it's not written in stone at that point, but judges will try to tie it up as much as possible. So you want to have as much, be prepared on the employee's end for exactly what you are willing to settle for and exactly what provisions in the settlement agreement you're willing to agree to. And your attorney should be able to walk you through all of those things so you understand, because not everything in the settlement agreement you're going to care about, but what the important parts are and what everybody's going to agree to at the table. And again, it can be a negotiating advantage because it can be a chip that you can play when things are kind of getting down to the wire, to move the needle one way or another on the number. So hope this is helpful. This is the end of this episode. Thanks for listening. I would encourage people to sign up for our Career Rocket newsletter. A lot of things are changing in the employment world. We've got artificial intelligence. We've got, global warming and what's going to happen to industries going forward as the earth changes. A lot of big changes in the employment world. And in the Career Rocket newsletter, we're going to help you keep ahead of all of that. You're going to get information about how to protect your career and also how to move your career forward. And unlike some other people who are producing content or information on career services, we're going to have that. And if you need them, and we hope that you don't, but if you need it, we're going to have the lawyers there to advise you. So sign up for the Career Rocket newsletter. It's free, and you can get the link in the show notes. Till next time, take care.